categorical ban on gay and unmarried couples from being both foster and adoptive parents does not further the interests of welfare, safety, or health of children in the state of Arkansas. Now, as Senator Womack has pointed out, the court did not hold in Arkansas cases that the ban violated the Equal Protection Clause, but there are several findings of fact that the court made that's on the issue of separation of powers that's relevant to the court's analysis for purposes of equal protection and the rational basis in the review. The findings on this point have already been made by an Arkansas court, Howard v. Department of Human Services. After a 5-day trial, the circuit court made several findings of fact and conclusions of law that are relevant to whether or not this law would pass constitutional scrutiny. The court specifically found, and I'm quoting part from the court's decision here, that the blanket exclusion of gay people from being foster parents is not rationally related to legitimate state interest in protecting the health of foster children. It is not rationally related to legitimate state interest in protecting the welfare of foster children. And it is not rationally related to legitimate state interest in protecting the safety of foster children. The court further found that being raised by gay parents does not increase the risk of problems of adjustment for children, the risk of psychological problems for children, or the risk of behavioral. The Arkansas Supreme Court upheld these findings, concluding that these facts demonstrate there is no correlation between the health, welfare, and safety of foster children and the blanket exclusion of any individual who is homosexual or who resides in a household with a homosexual. The court concluded that as such, the circuit court did not err, did not make a mistake, in finding that there was no rational relationship between the regulations of blanket exclusion and the health, safety, and welfare of foster children. In addition, the court actually found that the exclusion may be harmful to promoting children's health adjustment because it excludes a pool of effective foster parents when the system is in need of as many foster parents as possible to make adequate matches for children who are in the system. There's no reason to believe a court would not make a similar analysis for unmarried heterosexual couples as well. After all, if the categorical exclusion of homosexual couples is unconstitutional, it is likely that the same sort of categorical ban on unmarried heterosexual couples is unconstitutional. Also, the court's analysis seems quite applicable to adoptive parents. On this basis, it's my belief that the court hold this act unconstitutional should it be enacted.
Right here, I'll put it up here where you can see it. This is a body of evidence that was not submitted to the state Supreme Court in the Howard case when they heard this issue back a year or so ago. You look at this, you see there's a body of evidence here that says that indeed there is some harm to be done in situations where gay couples adopt children, serve as foster parents, or cohabiting couples do. And so I would submit to you that yes, somebody else could come and put another stack right beside this one. But if you have conflicting evidence here, I think this committee in the state of Arkansas has an obligation to err in the direction of safety. Florida have already done this. People who say that this is unconstitutional need to go and look at what Florida has done, what Utah has done. If they can do it, why can't we here in this state?
Well, just identify yourself for the record and your recognize.
My name is Barbara Miles. I'm a former foster child and I'm against Senate Bill 959. I'd like to tell you all, share with y'all how I've come to this issue. I was a foster child from age 4 to 10, and I was adopted at age 10. I was what the foster care system deemed as a hard-to-place child. The primary reason was because I was 10 years old at my age. Let's just say I have a whole lot of foster care experiences. It is my experience in foster care that has made this issue so incredibly important to me. I believe that the proper focus to adopt and become foster parents should be that parents should be capable, stable, loving, and caring parents. And I think that that comes in a variety of households. Unfortunately, I only know of 2 other adult children in foster care. Senators, I think that it would have been a complete tragedy had I been denied the critical relationship with a family because at a political level a decision was made that an entire category of people were deemed inappropriate foster parents or adoptive parents. I made it because I lived in a home where somebody completely and totally loved me, and I think that every child should have that opportunity to live in a stable, caring, loving home. Thank you.
My name is Diana Stogner. I am 23. I'm a senior at Hendrix, politics major, and I am in a stable home where I have a lesbian mother that helps me raise my 6-year-old son. Her girlfriend lives in that home as well. I also have a father that is gay and lives in a home with his partner. I am a successful young person that has lived through this experience and can tell you that there was absolutely no negative impact on me by having two gay parents. And if there was any impact, it was a positive one to open my eyes. Also, I would like to tell you how this directly affects me. In the bill, there has been some things said that leads you to believe that there is an exception for blood relatives, and that in my case, my parents could adopt my child if something were to happen to me, but that is not the case. If you read closely, the only exception is to cohabitating parents for a blood relative. There's absolutely no exception for a parent that has a child that is homosexual, that their child needs some type of placement. If something were to happen to me, my mother is the place where my child would go. Thank you.
Everyone is having this debate. It could have been a very emotional, what is a very emotional debate. Everyone has been very civilized about this discourse. I appreciate that. The decision to adopt a child is private. It is not a private case. In short, a person who seeks to adopt is asking the state to conduct an examination into his or her background to make a determination as to the best interest of the child in the adoption. The state's overriding interest in not providing individuals the opportunity is not to provide individuals the opportunity to become parents, but to identify those individuals who may be most capable of parenting adopted children and providing a secure environment. Back in the governor's campaign, this issue came up. And our governor Beebe made perhaps one of the most profound issues, statements on this issue that I've heard. He said that whenever a child is put in a situation where they're not to be placed in an adoptive or foster scenario, that child has already, in most cases, been through some sort of trauma in life. We don't need to add additional trauma to that child by putting them into a situation which is going to be a single attachment. It was also discussed whether or not a bill would be signed if it was constitutional. I think clearly the law is on our side that this is a constitutional thing. Ladies and gentlemen, what I'm asking you to do is consider whether or not this is what policy should be. Right now, it's in their hands, so I would appreciate it.
Pleasure committee, Senator Lawrence Rhodes, been passed.